So we've had the introductions, but the purpose of this round table is to discuss the experience of arbitral institutions in construction disputes. And what we thought we'd do is try and divide the discussion into four broad topics. The first topic is going to be what specific arbitration provisions help to manage construction disputes. And then we'll move on to the second topic, which is going to be a discussion about what opportunities and challenges exist for an institution in handling construction disputes. We'll then move on to the third, and the third topic is going to be what legal and contractual provisions should exist to expedite construction disputes. And then the final topic that we hopefully will get to will be what are the challenges for arbitral institutions handling construction disputes. Now hopefully it'll be a free-flowing discussion, although we have identified some colleagues who are going to take the lead on some of the subtopics that we're going to address. And I think what would be great, if this is at all possible, is if we can get some audience participation as well. I know we've got some experienced practitioners up on the stage, but I know also that there's a lot of very experienced practitioners in the audience. There's some very experienced arbitrators as well, and people who are just conversant in arbitration generally. So if you do have any specific comments, please don't hesitate to raise your hand, and I'm sure we'll be able to get a microphone to you so that we can have a free-flowing dialogue, both up here and also amongst the audience. So let's kick off by discussing what specific arbitral provisions help to manage construction disputes. And the first question that we have is going to be to Frida from the outset. And this is a discussion about provisions relating to joinder and consolidation in arbitration rules. And as many of us know who practice in this field, there is quite a lot of instances where parties do want to try and join disputes. I suppose the most classic example that, again, I suspect we've all experienced, is where you're acting for an owner and a contractor has brought in arbitration against the owner for, I don't know, extensions of time and additional money. And one of the reasons why they say that they were delayed and why they say they want additional money is because designs were late. Just the late provision of design information, or the design information that was provided was somehow inadequate. And the owner doesn't really know because they didn't actually produce the designs that are the subject of the complaint, because the owner had hired an engineer to actually provide the designs. And therefore usually what happens in that type of situation is that the owner will try and join into the arbitration the designer, so that the owner can then point the finger at the designer if the contractor is correct in their complaints. So that's a classic example. There's other examples as well that I'm sure many of you will be able to readily think about. So that's the context. So Frida, I'm just wondering whether you can give us some of your experience and your institution's experience of this joinder and consolidation.
Yes, like you mentioned, Emerson, thank you for the invitation. Like you mentioned, Emerson, you provided a very usual scenario when we have subcontractors, we have private entities, we have sometimes developed banks that even are involved in the construction or in the whole project. For instance, we can take a look at the AC case in Portugal regarding the project in Totamega. It was against Acciona and a couple of other Spanish companies, and this is public information, and of course they will try to bring the designers and the rest of the engineers involved in the dispute. This dispute, the claim was around 20.2 million euros, and the counterclaim brought by Iberdrola was around 60 million euros. So that's another very usual common when we have claims and counterclaims that are quite different. So as an arbitral institution, we have to decide whether we will use the system of separate deposit cost, or we're going to charge the parties after their joinder. So joinder in our rules, it's stated on Article 7 of the arbitration rules. We do not have a distinction between consolidation and joinder. We only talk about those issues on Article 7 and 16 of our rules. But some other rules, for instance, Article 6 of the SIAC and Article 7 and 8 of the same institution provide additional elements to decide whether or not one party could join the dispute. And I would like to point out a couple of issues. The first one goes to consent, because most of the arbitration rules requires consent from all of the parties, including the third party who would like to join the dispute. But the LCIA and also Hong Kong International Arbitration Center provides a different solution for this issue. So in the LCIA, you only need consent from the third party and from the party who wants the other one to join the arbitration. So I think that proposes a better solution than the one that we are facing when we are dealing with several parties in dispute, and of course most of them wouldn't like to be part of the same arbitration. And the other issue that I would like to take into account is, of course, the time or the stage of the proceedings. We are talking about the fact that most of the institutions, at least the SEC, the Stockholm Chamber of Commerce, determines and expressly states that the point to join is at when you provide the answer for the request of arbitration. So that's very clear, but not all the arbitration institutions provide that solution. And in addition to that, we have to consider whether or not we have an arbitral tribunal, because that brings a different thoughts and different solutions provided by different rules. So when we have the arbitral tribunal appointed under the SEC rules and also under the Hong Kong International Arbitration Center, the arbitral tribunal could be released if the other parties do not consent to the members of the arbitral tribunal. But for instance, in our rules, that's a decision that the General Counsel will make, whether or not we can have the same panel of arbitrators and we can bring the other party, and that party waive its right to appoint an arbitrator. So that will be a difficult question when we're talking about the appointment of arbitrators. And the second issue regarding consolidation, I would like to focus here on the applicable law, because under some arbitration rules or under some arbitration acts, as the one in the Netherlands from 1986, the court could have the power or the faculty to order the consolidation of arbitration. Of course, the parties and the arbitrators will have the right to make comments or to bring any kind of arguments, but I think that's a very interesting use of the consolidation figure. And in addition to that, I was reading that construction disputes and construction users are willing to use the Dutch law only because it has this possibility. And I think that could be very useful, and that could be something that we can also consider to incorporate in our arbitration law or rules.
Thanks very much for that. I don't know whether any of the other colleagues on the panel have any comments to make about consolidation.
It's a very brief one. Emerson, thank you very much for the opportunity. I just want to highlight the very frequent practice we are seeing lately about having additional parties, just partes adicionales, without a specification of the quality of its participation as a claimant or respondent, but just partes adicionales or additional parties. And that becomes interesting in terms of deciding how those entities will participate in the arbitration, in what type of I don't know, nature. So that's interesting because it the tribunal might face an interesting challenge of deciding whether those entities are claimant or respondent or are just like the audience of an arbitration, I don't know.
Yeah, of course.
I just want to say something which for me is very important when negotiating and drafting complex construction contracts, which is that the arbitration clauses have to be the same. in the contract between the owner with the contractor and the contractor with the subcontractors. Because in many occasions, you need to bring a subcontractor or a third party, and if the clause is not the same, you have real difficulties in trying to do. Probably what I'm saying is very naive and simple, but I understand that the owner or the contractor has to take care of that. That all the contracts have the same clause.
Yeah, I think that's right, and also the choice of law as well. You'd like to have the same law applicable to both all the disputes. The one thing that I've come across and advised clients on is this, and I suppose it's something I was mentioning earlier, which is about these multi-tiered dispute resolution clauses which you see. So many times I've seen situations whereby an owner has been sued by the contractor, and the contractor is able to do that because it's gone through the tiered dispute resolution procedure. It's had the executive meeting, it's maybe had a mediation, so it then goes to arbitration. But the same isn't true when the owner is looking to bring in the designer into the arbitration. There is the same multi-tiered dispute resolution clause which has to be ordinarily complied with. And if they've not complied with that with the engineer, it could mean that there is a jurisdictional challenge, certainly looking at it from an English law perspective. And therefore it's something I think drafters of contracts need to think about, is in circumstances where there is a request for consolidation or joinder, I suppose, that they should dispense with the multi-tiered dispute resolution clause, where you don't have to go for the executive meetings, you don't have to go to a mediation, you can just go straight to arbitration.
Yeah, and just echoing what Cecilia mentioned, I've seen recently that even the tribunals, they have set like a very specific deadline for the parties to add new parties to the cases because of the complications that they can bring if they do it at a very late stage. And as you said, they will be put in a position to decide whether those parties would be, it would be more efficient to have all of them considered in the same case, or perhaps opening another case with basically the same facts. Probably different issues, probably different contracts, but how they would play, a decision of the second case would play for the first one, or vice versa. So all those complications, I think, have been acknowledged, and even when arbitral institutions have provisions on that, and parties should have to be very careful on what rules they adopted and to read carefully what the rules provide in order to be very clear on what they can do about joinder and consolidation.
That's a good point. Moving to the, I suppose, second subtopic under this umbrella of how arbitral institutions manage construction disputes. The next topic that I was going to ask Yanette to just discuss is the recent rules of the AAA, and if she could just provide us with, I suppose, an overview of how those rules are applying to construction arbitrations.
Sure. So I just want to make a brief comment on how the structure of the AAA works. And for those that don't know this, we have obviously the ICDR, which is the international arm of the AAA, but besides that, the AAA has been working on having different rules for different sectors or different areas. So even when construction is added to the commercial sector, they have their own rules because of the importance and the specifics and all that the industry needs. So because of that, we have a specific set of rules for construction disputes. And in November 1st of last year, a new rules or procedures were created. Also, the Dispute Avoidance and Resolution Board, which is DARB are the easiest way to mention that. So basically what this is created is this committee for, avoid further disputes in the case, just creating, it is either a 3-member committee or one person that will be monitoring all the course and the life of the project, and perhaps avoid the parties to come into a actual arbitration or litigation, even if they choose to do that. Obviously, the general terms of the rules provides for how this board will be selected using our list method, which is, you know, the preferred method for the AAA for all the selection of their neutrals. And also it has a couple of different forms to resolve disputes in this during the life of the project, which is the interim advisory process, which is not binding to the parties, or the formal process, which is actually, you know, filing a request before the board, considering arguments, evidence, perhaps a very brief hearing, and then making a decision. In what level this decision will be binding to the parties, it depends on what the parties decided in the arbitration agreement. And, well, basically that is what came into force last year. But again, besides that, there's a specific set of rules for construction industry, which in this, at this moment are also under review. We've been doing several groups in different locations just to learn if the construction rules actually need to be amended. The AAA ICDR has been very careful on not, you know, changing anything that does not need to be changed. So we are, you know, just in terms of discussing if the rules are actually fulfilling the needs of the market and, you know, all the new trends. So far, I think that the changes are not very, you know, important changes. It's just more in the sense of being more transparent and, you know, diverse and all those, you know, concerns that we have at these days. So this is where we are now. And actually, I also want to mention for the ICDR itself, the construction industry is also very important. We have around 10% of the cases we had last year were construction disputes related. So it's also a very important sector. And another comment I want to make is that the ICDR can manage cases under ICDR rules, but also under the construction rules if that dispute has an international component according to the UNCITRAL definition.
Thanks very much. The way you described the procedures that were rolled out in November of last year, it's very similar, I think, to the ICC rules on dispute boards. Seems to be some overlap. The one thing I always get asked by clients is, well, when you go to the arbitral institution to make an appointment to a dispute board, and this can be open to all colleagues to answer this question, is to what extent do they adopt different criteria to when they are trying to, or when they decide to nominate an arbitrator? So what are the different characteristics you would deploy for an appointment to a dispute board as opposed to an arbitration? Could you just give us some insight into that?
I can just say that we have a very specific, we actually have a list of arbitrators for mega projects in construction. So that is a very specific panel that is related just to those type of projects and disputes. Besides that, the way our system is designed is that we, you know, highlight which is the major expertise of the arbitrators, or even people that are not considered arbitrators, but they are neutrals for other types of cases, such as the DIRB. So, and that will be highlighted in our system, and that's the way we would work with the parties, obviously, because they have to say, they always have something to say before we start all that process, and then, you know, consider what the arbitrators have been trained on and what they are their major expertise, their major experience, what cases they prefer to. They are also, you know, people that have very good experience being as an arbitrator, and they don't want to be in a DRB. So it depends on also what they want.
Also, in my experience,
Thank you. In my experience, it will be difficult to find today an engineer acting as arbitrator. I think in dispute boards, it will be more frequent to have engineers. We can, of course, find arbitral tribunals with co-arbitrators being an engineer, but it's always important to have at least the chairman of the tribunal being a lawyer. So probably that would be the first decision to make from the institution, should be a lawyer or another type of professional.
That's good to know. So certainly in my experience, DABs, I think having an engineer as a member of a DAB is really crucial. They just approach things very differently, because ordinarily the disputes are during the course of the project, and the engineers just have a mindset of being practical and trying to find a solution that's for the interest of the project. Where there's a slightly different mindset, I think, to arbitrators who usually come at the things at the end when the project has been completed. And certainly, just picking up on what you were saying there, I've had so many engineers as arbitrators who have been absolutely fantastic. They've been really good, so I'm all for trying to get an engineer as a member of a tribunal. Does anybody in the audience have any observations, questions about this particular topic before we move on to the second one? No? Okay, we're going to move on to the second topic. So this is what opportunities and challenges exist for an institution to handle construction disputes. And the first subtopic is a topic that I've been talking about for a number of years. And whenever I do, I almost think as though I'm in a therapist chair, because I just go off on one and I just keep talking about it all the time. So I'll tell you what the topic is, and then I'll just give you some of my observations. So the topic is this, or the subtopic is this: how institutions manage arbitrations in order to ensure that awards are published expeditiously after the conclusion of the evidentiary hearing. Now, the context to this question is this, again, I've had so many clients complain about arbitral institutions and about arbitrators. What they do is, or what the clients say is, they set really aggressive timetables in the arbitration, where you have to serve witness statements very quickly, expert reports very quickly, evidentiary hearings are set by the calendars of the arbitrators. And then once the evidentiary hearing is closed, and once the parties have submitted their closing briefs, you don't hear anything from the arbitrators. It seems as though things go into a black hole, and you never hear anything other than an email from the institution saying, you've got an extension to issue your award. And there's no involvement of the parties. Nobody quite knows what the arbitrators are doing. Nobody knows whether they're actually consulting with each other. And it just seems as though, certainly a lot of clients that I act for, they're getting pestered by their CFOs, because the amount of money in dispute could be market moving. So investors are wanting to know when an award is going to be published. And invariably the answer is, well, we just don't know. And it seems to me, and certainly to clients, that is so unsatisfactory to have a situation where, despite the rules, the ICC have rules about when you're supposed to publish the award. I think the ICSID does, I think the AAA does. All these institutions, they say, oh, it's going to be 6 months after the closure of the evidentiary hearing. We never get an award in that time. So that's me just telling you my complaints that the clients tell me about. So what are the institutions doing in order to listen to and act upon what clients are actually saying? Because they're the ones who pay, if I may say so, your bills. So, Jose Maria, I think you've got an answer for us. And what I'll do then is I'll throw it open to the floor before I ask anybody else, because hopefully there's somebody who's going to support me in what I'm thinking.
I share entirely your view, and I think this is a real issue in arbitration, because arbitration is a matter of confidence, of credibility. When people go to arbitration, it's because they expect to get something better, that what they can get from the state courts, but not only in terms of quality, but in terms of time and in terms of costs. And in this, to keep those things in the right way, institutions must have a very important role. I think there are two phases. One is the election of the arbitrators, because you have to think not only if it is an expert or a very capable arbitrator. You have to be sure that he or she has the availability to conduct the arbitration on an expedited way. And this is not always the case, unfortunately. As the ICC did in some time ago, we also in THIAM asked for the arbitrators to express clearly, their availability in the coming 20 months, in order to know exactly the number of hearings they have, the number of arbitrations, and if they are busy, the court will not confirm or will not appoint that arbitrator. And the second, we have put in place several working groups. One of it is a construction working group. We don't have a closed list of arbitrators, but those groups that are formed by arbitrators and lawyers and experts that know very well the field and the activity and know who is doing things well and who is not doing things well. You mentioned the time that goes from the post-hearing briefs until the award is communicated to the parties. But I think there is a previous phase which we have to take into consideration, which is the agenda of the arbitrators. I've been placed in a situation where it is totally impossible to find out days free. For the hearing, and it takes months and months and months, and this is totally unacceptable. Totally unacceptable. If you don't have time, what you should have to do is not to accept the appointment. As simple as that. And then the communication of the award. In THIAM, we have a scrutiny phase, as in the ICC and others. I think GAM also has this. And we have to push, and we really push the arbitrators to render the award in a period not over 3 months. And apart from establishing sanctions, which is a good idea that came from the ICC, I think was Alexis Moore, the one that, and to say, you are touching the pocket of the arbitrator, and if you delay that, you will suffer the consequences. And of course you need a very good precedent, because in some cases the delays on the deliberation process come from the party-appointed arbitrators. And there are all the time new deliberations, and the president must put an end to the deliberation process, to say, well, we have discussed everything, and that's it. I was thinking, of course I haven't commented it to the courts that form THIAM, because we are the international branch or arm of the Spanish courts, to put a limit. I don't know if I was thinking in 2 years' time, and to say, to put this in the rules, in 2 years' time, you arbitrators and lawyers have to manage to do everything. And unless both parties agree to the extension of that period, then you have to render the award in that period. I don't know if this will be accepted or not. Well, we have to do something.
Yeah, we certainly have to do some. Just picking up on that last point before I just opening it up to the audience for views, and then I'll come back maybe to get some other views, particularly from the ICC. The issue of asking the parties or the parties' consent is that once you get an email from the presiding arbitrator, which is words to the effect of, this is a very complicated dispute, we want to do the best for the parties, it seems as though it's thrown up lots of issues that we hadn't really anticipated, we need an extra 3 months in order to publish our award, it's going to be a very brave party who's going to say no. Because they'll think, oh well, we'll get on the wrong side of the arbitrator. Now, there is obviously a way around that, which could be the parties' views could be communicated to the ICC or the institution, and they then just provide the arbitrators with the answer. It's either both parties have agreed, or no, you don't have an extension, and the tribunal doesn't know which party has, as it were, said no. That's one route. But it's always quite difficult as counsel, when receiving those type of emails, to say, no, I want you to render your award. I like the idea of docking pay. I think that's really good, and we might want to just come up, because that is an ICC thing. Don't know whether it's used in practice, so I'd like your views on that.
Yes.
But you've got bad experience maybe.
No.
We'll come back.
Unfortunately not, but I haven't seen that.
Because I haven't seen it, but I've got 3 cases at the moment, which I hope the arbitrators will be penalised. But we'll just hold that thought for the moment. Has anybody in the audience got any particular comments, observations, questions that you have on this? I suppose I'm leaning on you to think of ways around the problem of forcing the tribunal to issue their award in a timeous manner.
Probably if someone would like to make a comment in Spanish, you're welcome to.
Omar, let me come over to you. As long as I can have the mic back.
Sorry. Just probably, well, first, thank you very much for coming from abroad and dispersing some of your activities to come here. Thank you very much indeed. Just a quick question. From the arbitration institutions, and just having passed the technology panel that we had before, do you envision that will be necessary to probably have some sort of amendments in order to have these technology trends, or what are your thoughts about all this regarding technology implemented in arbitration institutions? Thank you very much again for your thoughts.
Well, I think that technology is very important, and in fact, all the international arbitration centers use technology as a tool. But I don't think, at least in my impression, I mean, and living it in many occasions, the problem is not the use of technology or not. It's the availability of the arbitrators. And in many occasions, I insist, the position taken by party-appointed arbitrators that delay the deliberations. This is and this cannot be solved with technology. In the end, it's a question of judgment. Of course, technology has to be there, must be there. All of us need to improve technology, and I don't think, in my opinion, we must put a limit in the rules for the rendering of the award. In the Spanish arbitration law, you have 6 months for domestic and international arbitrations. 6 months from the answer to the claim or the answer to the counterclaim, and it can be extended only 2 months. If not, the award would be out of time. But in other institutions, I mean, they are continually granting and granting an extension And we go ahead.
I would like to provide a very brief comment on arbitrators' defense. Defense. En su defensa. I think there's a duty from the parties in terms of selecting the arbitrator. I have participated in several meetings with clients who want the busy, usual suspect arbitrator. So and you propose different candidates and you suggest excellent practitioners as arbitrators, and they want the magic circle to participate and to act in their tribunal. So that's another duty we need to discuss on clients and on lawyers in terms of suggesting different names and extending the group of arbitrators. Otherwise, if the client wants the famous arbitrator, they will have to face this type of delays because of the agenda. So it's on both sides. I think it's something that we need to, discuss everyone, all of us, as practitioners.
Yeah, that's a good point.
Right, so I just have a comment on that too, and it was kind of echoing again what Cecilia said. So on the part of the institution, I think it's obviously a concern. We have received those critiques, and we know that arbitration is, for some people, is not seen as efficient and expedited as it should be. So, and I think generally speaking, I think all institutions have addressed the issue and have discussed it and have made efforts to improve that. From where I am, I can tell you our responsibility is training with the arbitrators, and just let them know that according to our rules and our policy, they have to render the award in 30 days. 60 days. ICDR rules provides for that, and an extension is not the option, it's the exception. So only under very unforeseen circumstances that those extensions are granted. And the tribunal needs to go first to us, and then we need to go to the parties. So there's no, that direct communications with the parties in that situation, even though they, as you said, the situation comes and the parties would not easily reject the extension, right? But on that part, I think training is a very important part, so the arbitrators know that when they take a case with us, that will be the situation. They would also have to know that this request for their availability is very important. So I have received several responses from arbitrators saying, I'm sorry, but I cannot do it. I don't have time until next year for a hearing, and if that doesn't work for the parties, I'm not going to do it, which is really good. We really appreciate honesty. And that's related to my second point, which I think it's an exercise of honesty, and that comes from the arbitrators and from the parties. Because the arbitrators need to really, really, understand that what they can actually complain in terms of dealing with cases. So that is a very important exercise from my perspective, and also from the parties, because if they want that arbitrator that is really, really good, but it's also really busy, they will face this situation, and then afterwards they want to be upset with the institution because they don't have an award within the time frame they expected to.
Thanks very much.
Can I?
You go.
First of all, Emerson, we feel you. We have had clients saying that whether it would be a possibility to file a liability claim against one arbitration institution because of the delay. We said that it would be difficult and probably not the best advice, but just in case. So touching upon on the honesty, I am aware of at least one case where the arbitrator was challenged because the party challenging the arbitrator said that he had misinformed about his true availability when filling in this ICC questionnaire. I don't know if that was the only case that I'm aware of. I don't know if you've, what would be your institution position in case of a challenge because the arbitrator is not actually available as he said he would be?
Again, I would go to the rules. For example, the ICDR rules has a provision that allows the parties to ask for a removal of an arbitrator because of availability or not complying with the duties of management of the case. So until now, I haven't seen it, but I'm really eager to do because that's again the rule. The parties have that power. They are not utilizing it just because of that fear, and that's also not fair. Because on our side, we're doing our best to give the tools, but if they are not used, there's also nothing we can do. On the other hand, I have cases where we actually took like an active role, just picking up the phone and talking to the arbitrators and saying, you know what, you can take like 2 months to issue a procedural order. This is too much. So we need to know what's going on in the tribunal. If you're having trouble even dealing one with each other, because that's also something that happens and that may delay the proceeding as well. So, but that thing, I think it's more like the role that the institution is needed to address at this, with all how arbitration has been acting in the recent years and how we need to be more active in terms of pushing the arbitrators to do what they have to do, so that we can do what we can do, or we have to, and also ask the parties, you have to do what you have to do, because if the provisions are there, if the rules are there, you are able to use them, and just don't be afraid to do. So.
And I have a comment. The Danish Arbitration Center has a rule that if they don't issue the award within 6 months, it's going to be void. So according to the Secretary General, they have never had a case where the arbitrator surpassed that time. And just to comment, what do you do when the hearing has passed, but parties have not paid the costs or the fees of the institution? I mean, if I were to be the arbitrator, I would have the suspicion that parties may be negotiating, trying to settle, and perhaps I am drafting the award, but they are not very keen to see that award because they are trying to settle, they don't want to pay. I don't know if you have any experiences on that.
As an arbitral institution, we try not to get to that point when we don't have the deposit, and we try to get the deposit first. But also, when it comes to construction issues, you know that the claims are changing all the time, so we try to keep and we try to consider additional expenses, for instance, for the arbitrators, and we also have to check with the arbitrators whether or not the claim increased or we have any kind of significant changes, because when we take a look first with the notice of arbitration, we can have just an idea about how the arbitration will develop, but in the end, with all the memorials and with the information that we have and the experts, or the hearing could be more expensive. So then we can request the parties first before the arbitrators are drafting the award.
So that this topic is having so much debate, it's great. I'm just going to have one comment. I'm going to have another comment myself, and then we'll have to move on to the third topic, I think.
Thank you, Emerson. Orlando, on your comment, in my opinion, and I'm speaking as arbitrator, I wouldn't stop drafting the award because I think that there might be something going on between the parties. I mean, I think you have to use the possibility of communicating with the institution and probably ask the institution to double check or touch base with the parties and see where they are. But I wouldn't stop the drafting of the arbitration unless you have an express request from the parties to stop because they are negotiating or starting a negotiation window. But I mean, only because I wouldn't stop it.
This situation you have mentioned, I think it's very rare to happen. because normally the parties pay the costs at the very beginning, and the institution has the duty to contemplate the whole proceeding. So normally there is no new, at least in my experience, asking for further costs at the time of the hearing. Everything comes from the outset.
Yanette's going to
Yeah, it's a
comment.
very good comment.
Because the ICDR system is a little bit different from ICC and others. So the ICDR pays the arbitrators on hour rates basis. So we definitely prevents the arbitrator to keep working and keep billing for that time. So just wanted to make that clarification because the system is a little bit different.
That's a very important point. Thanks very much for that. Just to conclude this, I just want to have some thoughts that I have about how to try and resolve this as best as you can. I think it really all is based upon transparency. And what do I mean by that? What I suppose I'm meaning is that after the evidentiary hearing and the parties have submitted their closing briefs, I do think it is incumbent upon the tribunal to inform the parties the dates in which they're going to deliberate. I see no reason why a tribunal can't do that. And when they provide the dates in which they're going to deliberate, inform the parties what they're going to deliberate on. There's no reason again why the tribunal can't do that. And so that's point one, transparency. The other point, again, linked to transparency, is when the arbitrators write to the institutions and ask for an extension, I've never seen that correspondence, and I don't see any reason why the parties cannot be copied into that correspondence. And I think it is incumbent upon the institutions to actually push back and question some of the reasons why an extension is being sought. Because I suspect the extension is being sought because they're just too busy on other cases. And it's nothing to do with the complexity of the case, etc. And I think there really needs to be, if there isn't already, a really detailed review by the institutions as to the reasons for the extension. And I think if there is, and it is properly considered, I think clients will be okay with that. I think at the moment, because there is a lack of transparency, clients are just upset. You just go into a hole, you're paying lots of money. Sometimes it can be millions of dollars in advance payments, and you just don't know what's going on. I have no idea, so I think communications between the arbitrators and the institutions should be made available. And they should also, I suppose, be an opportunity for the parties to write to the institutions directly and question why, if this is appropriate, question why an extension is required. So that's just some of my thoughts. We're going to move on. I'm going to skip topic 3, if that's all right, and then move on to topic 4, because again, I think there's one subtopic that is going to be particularly interesting to everybody in the audience. And so the 4th topic was, what are the challenges for arbitral institutions handling construction disputes? And the first subtopic is increasing diversity and arbitral panels. Now, again, by way of context, a lot of my clients, particularly in America, the United States, and in Europe, are asking me and my colleagues, when putting together lists of potential nominees, women. If we don't put a woman on a potential nominee list, there's huge questions as to why. What is it about you as a firm that you can't identify a woman who could be an arbitrator? And they're absolutely right about that. Less so in, say, the Middle East, and less so probably in Asia, but certainly in Europe and certainly in the States. So it's been driven by the clients, which is really, really important. And also coupled with that, there are a lot of initiatives out there at the moment. I'm thinking, for example, the ERA initiative, where people are subscribing to a requirement that I think at least 30% of panels consist of at least one woman. And I think construction has a particular issue, if I can put it like that, with women. there just aren't sufficient women who are specialists in construction disputes, and that really needs to be resolved, it seems to me. So I'm just going to throw this open. Jose Maria, I think you're going to kick us off on this. What are the institutions doing in order to make sure that panels are diversified? Maybe not just in terms of women and men, but other ways as well, nationalities, etc.
Well, I think the start point must be to structure yourself in a diverse way, which means that in our case, in the International Madrid Arbitration Center, all the committees, we have the appointed committee, the challenge, the best practice committee, the scrutiny, all of them have to be formed by 50% Europeans, 50% from Latin America, and 50% men and 50% women, all of them. So if the structure is such, the tendency at the time of appointing arbitrators and respecting diversity will come as a natural way. Is what I think. Of course, in many occasions, more than in terms of nationality, but in terms of gender. I mean, we have to admit that there are more men specialized in construction than women. But it is coming, and this is coming very rapidly. And institutions must have the commitment of speeding up that process in order to include, and in all the names that we provide that to the parties, try that. I mean, if it is not 50-50, it is close to that, women and men.
Thanks for that. I know from experience the ICC, I think, at the forefront of this. I think they've done a great job over the last couple of years. And am I right to say that the ICC now, in the letters that are sent to parties when the arbitration is commenced, they actually include language to the effect that it is important for the parties to consider diversity when nominating arbitrators?
Absolutely. I think the ICC has played a very important and significant role in diversity. For example, the interaction between the ICC and the national committees, as per the suggestion of candidates, is very strong in terms of, taking back the list if that list is not diverse enough. If you, as national committee, prepare a list of candidates to the ICC Secretariat for an appointment, and you don't include enough members, women, and diversity in terms of nationality, etc., you get that list back, and you get an indication that you have to repeat the list and do better. So yes, I think there are very specific trends on that, and the role of the ICC in that regard is very important. I just want to mention that law firms, have also a very important role in this, and I want to mention the leading role of women in an audience, for example, in a hearing, I meant. We need to see more women acting as leading counsel, because that is going to give them enough experience to act as arbitrator afterwards, or in another type of activity or role. So law firms are very important as well.
I think also when we're setting up panel discussions like this, that we do make sure that women are participating, like we're doing here. I think that's really important. It just means that more people are familiar with women arbitrators, etc., etc. So I suppose encouraging colleagues who are women to actually participate in these types of events is really, really important. And I agree with you. I think law firms have a huge job. And I was just speaking for myself. When we put together nominees for an arbitral appointment, it will always include a woman, without any question. And I know there's some absolutely excellent women arbitrators who are construction disputes, construction arbitrators. But more than that, when hiring experts as well, women, there are some absolutely fantastic experts who are women, and I will say this, and this is anecdotal, they're actually better than the men. And the reason for that is because they actually read the papers. and they're a lot more organised than certainly the male experts. So yeah, speaking for myself, and I know colleagues as well will adopt the same view, that making sure that women are on shortlists is absolutely key.
Yeah, I just wanted to share and obviously confirm that I think that the institutions we, generally speaking, we have led this initiative of increasing diversity and all of that, but I also agree that this is a joint effort. So my only additional comment would be that also women arbitrators or diverse arbitrators, don't be afraid to apply to be in panels. We have a panel, a closed panel. So, and we remove and add people every year based upon reviews and their performance and things like that. And I keep inviting people to, you know, apply. And sometimes they might not get into the first round, but just keep trying. And that's the only way we will be adding new people to the panels and to the arbitration practice.
That's a good point. Any observations from the audience on this particular topic? Nothing? I'm just going to go back to what was our topic 3, if I may. We've got about 3 minutes left. And the third topic that we're going to discuss, or we are discussing, is what legal and contractual provisions should exist to expedite construction disputes. And the question that we're posing to ourselves, which Frida, if you wouldn't mind taking, is the appointment of tribunal-appointed experts to resolve smaller claims and counterclaims. And just by way of background, I suppose what we're thinking about here is lots of construction arbitrations will involve a multitude of claims. We've all been there where there's a lot of claims for, say, change order works or variations. And there's a whole list of them that are put out in a Scott schedule. And they're relatively minor in monetary value. And the question that a lot of people have is, well, why do we need these very expensive arbitrators focusing upon those particular claims and counterclaims which aren't really central? Isn't it easier and wiser to have tribunal-appointed experts to look at those individually? So, Frida, I'm just wondering, from an institution's perspective, what their position is.
I think that in that scenario, we're talking about a very proactive arbitral tribunal who's willing to take that challenge to appoint its own expert. And we all know that the arbitral tribunal has the faculty and the power to conduct the proceedings, at least under our rules under Article 21. But what I have seen is that it's not very, very common. The arbitral tribunal is not willing to do that. And also, when I was reviewing additional rules on Article 34 of the SEC, when they appoint an expert from the arbitral tribunal, it is the arbitral tribunal who has to give the details and the information that the expert has to provide in writing. So I think that's a very useful tool. And then in addition to that, of course, the expert will provide a report that the parties could comment. And in addition to that, upon request of one of the parties, they will have the opportunity to bring the expert and to cross-examine the expert at the hearing. So I think that will provide the parties with a reasonable opportunity to present his case, and will bring additional issues, and I think will provide a better solutions for the issues that the arbitral tribunal needs to focus on. And the tribunal, in the end, it has the power to determine whether or not that evidence will be relevant or material to the outcome of the case. So I think that it is a solution. It is provided, as I mentioned before, it has an expense of the arbitral tribunal, so that wouldn't increase any kind of cost of the arbitration.
If we did the procedure that you just summarised there is consistent with the IBA rules on tribunal-appointed experts as well. This idea again of transparency. making sure that the parties have an opportunity to challenge the preliminary views of the experts. Has anyone got any other views? I know our time has run out, but I think we do. Yeah.
I must say that I am personally against. I'm personally against the appointment by the panel or the arbitrator, his or her own expert, because you face the risk that having a second or fourth arbitrator in the panel. And I do rely on the parties' experts, and there are many ways to get the information you need for these joint conferences and identifying the issues that are important for the panel, and in many cases they do agree. This is my own experience, because they come at the beginning of the hearing in a totally opposite position, and they converge when you put them against the wall. But calling a third arbitrator increases cost, increases time, and you face the risk to say, well, I have had to appoint a third arbitrator because I don't rely on the parties' experts. So in the end, you take what this third guy has said, and this is, for me, not a good solution.
Very risky.
Thanks for that. Orlando's hovering over my right shoulder, which means that we have to stop. Is that right? Thank you very much indeed, Hannah. I thought that was a very engaging discussion. Thanks very much. Orlando, I think it's over to you to close things up.
Thank you very much.